You cannot, as a matter of law, recall a sheriff for saying that he will enforce a law that was duly enacted by the legislature. You can't do it. I mean, it's just crazy.
Everybody ready?
Yes, sir.
This is case number CV0022171, Sheriff Mike Allen versus Tami Rae Spero, ex officio county clerk of Humboldt County, Nevada, and Laura R. Bento and Christopher M. Bento, members of the Notice of Intent Committee. Why don't we start over here? You go ahead and identify yourselves and we'll go around the room.
Good afternoon, Your Honor. I'm Humboldt County Sheriff Mike Allen.
Your Honor, Stephen Balkenbush. Mike MacDonald, Humboldt County DA, and with me today is Tami Rae Spero, the Humboldt County Clerk.
Rendall Miller, and with me is Jeffrey Miller, law student that's sitting in and helping me with my paperwork. And then I also have the Bentos with me.
Okay. Can't see him, but I okay. There's a whole lot of issues in this case. I've read all of the pleadings. My inclination is to have, starting with, because the sheriff is the plaintiff in this case, tell me what issues you think we're here to hear today, Mr. Balkenbush.
Your Honor, the issues that we raised in our brief are the issues that we want to talk about today. And those issues pertain to whether there's enough signatures for the petition to go forward. Also, Your Honor, there's procedural issues with respect to how this recall petition was handled. So we want to talk about those issues. Your Honor, we also believe there's constitutional issues pertaining to a resolution of this matter, and we want to talk about those. And so those are primarily the issues we want to talk about, Judge. And so that's what I kind of give you a little bit of a role.
Okay, so can you all hear me okay?
Yes.
If I understand, you're contesting the sufficiency of the number of signatures to call for a special election. What's the procedural issue that you're?
Well, Your Honor, there's a number of procedural issues that we want to address, and those are dealing with the Notice of Intent Committee, the fact of the matter that we believe the Notice of Intent Committee is required to have 3 people on the committee, and midway through, one dropped out. That committee is also charged with being, if you will, the shepherds of this whole petition process. And we believe that the statute requires 3 members to be on it, and there weren't 3 members on it. Do you want me to just give you a general idea? Is that what you want to do?
Yeah.
That essentially, there were 3 to start with. Petitions were submitted in 2 different batches, 1 through 45, and I think 45 through 46 through 50, through 58. The first batch was submitted properly because the committee was still in force effect. It had 3 of its members. There were only 3 members. The statute requires 3 members. The second did not have the 3 members submit the petitions to the county clerk because one of the members had resigned. Not only did he resign from being on the committee or the Notice of Intent Committee, he also resigned or withdrew his name from the petition, thus leaving only 2 members in what we believe to be required by statute, 3 members. So we feel that The second packet that got submitted was submitted improperly because it was only submitted by 2 of the members, because the third member didn't exist at the time or had resigned from his position. And so that's one of the procedural issues that we've raised. And we also think, Your Honor, that recently the Nevada Secretary of State, as the court is probably aware, redid the count in this case and determined now, at first determined there wasn't enough signatures, now it's determined there are enough signatures. And one of the reasons that she did that was because packet number 53, which contained 15 signatures, one was a duplicate. They added 14 signatures back in, the Secretary of State did. And we believe that packet, because it was in the second batch, wasn't submitted by the full notice of intent committee, because there was only 2 members at that time. So we think that invalidates the signatures that were just recently counted or authorized by the Secretary of State. So if that's true, then the numbers aren't sufficient enough. So that's one of the issues, Your Honor. And the other procedural issue, or one of the other procedural issues, is Judge, and I should have mentioned this to begin with, but the petition, we believe that the petition is insufficient as a matter of law. That's probably the biggest issue of the case, because what's happened in this case, as there has been the position taken by in the petition, is that the sheriff has stated, it's not an issue of opinion, it's stated in the petition that Mike Allen has stated publicly he will not support and defend the U.S. Constitution, specifically Amendments 2, 4, 6, and 14, nor the Nevada Constitution, Articles 1, Sections 11 through 18, violating his oath of office pursuant to NRS 282.20, and violating the Bill of Rights on which the nation is founded. We've offered an affidavit on that, Your Honor, but he has never done that in his life. He's never said he would support and defend the Constitution. In fact, he's required by law to do that. And Judge, that's why we think the petition is invalid in and of itself, because one, what they've stated is inaccurate or true, and I don't think there's anybody here today that would testify to that is true. That he has publicly stated he will not support and defend the U.S. Constitution and those specific amendments under it. Judge, what we have here today is the most unusual situation one could possibly fathom, because it's just this. The sheriff, and Judge, to be quite honest, this is really kind of a Second Amendment case, if you will. It's about really the underpinning of it is the right to bear arms. One of the ladies that was behind it owns a gun store in town, and a bill passed, that AB 291, and it deals with when people in a family setting or in a specific household, there's problems there, and they know of it, that somebody might be using a gun they shouldn't use, that they can report that. And then actions can be taken with respect to that. But the sheriff was asked one day whether he would enforce that, whether he was going to enforce that law. He said he would. He said, yes, of course I will. I mean, and he didn't think it's constitutional necessarily. He didn't believe it was, but he said, I will. I'm duty bound to enforce the law. So when that happened, after that happened, everybody says he's anti-Second Amendment. He's won't support the Constitution, and here we are. And this is where the language came from in this petition. And we think that you cannot, as a matter of law, recall a sheriff for saying that he will enforce a law that was duly enacted by the legislature. It's that simple an issue. You can't do it. I mean, it's just crazy. Now, if the judge, if the sheriff decided, I'm not going to enforce a law, then he can, then misfeasance, malfeasance of office, an action can be taken, or even put in one of these petitions. But all he said is he's going to enforce the law. So that's why we think the petition is insufficient as a matter of law, because you have to provide a reason in a petition, and in a petition you can't provide something that's untrue in the petition on its face, which this is, and expect the petition to go forward. Because the court can well imagine that with this type of statement in a petition, the whole world wouldn't sign it. It says you want to enforce the Constitution. And it just simply isn't true. And that all arose from AB 291. The applicants in this case, or the petitioners, the defendants in this case, Your Honor, their position, what was I going to say? Anyway, they agree that the gravamen of this whole petition is AB 291. They said that in their points and authorities. They said that is the central reason why this petition was filed, and we agree with that. That's at the nuts and bolts. Is this man is being they want to have him have to go through an election process for saying he would enforce a law that was adopted last session, AB 291, the red flag law. And we do not think that this petition on its face passes muster because of that. So that's that procedural issue. And with indulgence, I think those are the main issues, Judge. And I think I've talked about this, but Your Honor, the recall petition on its face violates the separation of powers clause, because what we have here is the sheriff doing what he's supposed to do, enforce the laws. We have the legislature that adopted it, and we have the court which interprets the laws. And he is being attacked for doing this very thing that he's supposed to do. And we think the petition on its face violates the separation of powers clause as set forth in our brief on this issue too. So I think those are the main issues, Judge, and we have to respond to any questions the court might ask.
Okay, Mr. McDonald, did you have anything you wanted to add to any of that?
No, Your Honor. Pursuant to regulation, the court has to be named as defendant in this type of proceeding. And we did file an answer. We addressed some factual issues that were part of the clerk's function in this process. Outside of that, the answer by our Humboldt County Clerk indicated that in her official capacity as Humboldt County Clerk, the filing officer for this recall petition and potential election does not take a position on anything alleged in the complaint. So with that, we too will answer any questions the court may have, but with that, we'll dismiss.
Mr. Miller? This is, I get weird because you've raised some issues too separate and apart from those. Go ahead and respond to him and then tell me what issues you want to raise. And I suppose, because you guys have raised a whole bunch of things here and we can discuss them as we go along. Go ahead and respond to what Mr. Balkenbush said, I guess.
We're here for the court's order to show cause. Okay, so that takes care of one motion.
Maybe somebody could tell me what the status is.
Any preliminary issues we need to take care of?
We'll make sure that she's put on house arrest.
As the Supreme Court has
Okay, why don't you give me the statute? I'm not putting up with any of your crap here today.
Okay, well, presiding, starting out, some procedural issues. There were 3 signatures on the notice of intent, and statute said that that notice of intent is valid until call for special election. So if there is no procedure for revoking your signature off, it said in the statute clearly say that it is in effect until that time. So we don't believe that there were only 2 members. We believe that there were 3 members and that were available that didn't void the notice of intent at that point. The recount that was conducted, so there was an appeal that went to the Secretary of State. The Secretary of State then had the additional signatures verified and added into the total sum, which took us over the number. I think that particular issue, I mean, that kind of lends into what we're going into and some of our points, but we do feel it's sufficient. I mean, we have over 502 signatures, which is 502 is what the number was required, and we met that after going through the appeal with the Secretary of State.
So does anybody argue that, if I understand correctly, there were batches submitted? The first batch had 544 signatures, and there were a certain number of them that were disqualified. And then there were batches after that this Mr. Butterworth, or whatever his name was, had withdrawn from the enterprise. So all the ones submitted after that, it's the position, if I understand correctly, the sheriff and the DA, that those signatures can't be counted, and if they can't be counted, then there aren't enough signatures. Would that be an accurate summary of?
Yes, the sheriff saying that they can't be counted. We're saying that they have been counted. They need to be counted. And we're over to them.
Okay. But the only way you can get to over the number is if you include ones. Is it Butterworth? Is that his name?
Butterfield, Your Honor.
Butterfield, Mr. Butterfield. The only way you can get there is if you add signatures that he didn't sign to forward.
Yes, but there's no requirement for signature on the submittal. It just says submit when it's talking
Well, it
about-
says the persons filing a notice of intent shall submit to the filing officer. That's what that.
Yeah. And then if we go down to 016, it specifically states sign and submit in 2 different places. Up in 015, it says signed and signed by. When there's a signature required, it specifies that sign and submit. And it uses submit in a location, I believe it's 016 as well. I have to go back and look at my notes, but there's in one location, there is a submittal by the filing clerk to the clerk where it just uses submit, and so presumably there's no signature required. So that's part of our argument, is that the submittal does not say sign and submit by all three
It
parties.
doesn't say anything about signing, it just says they should submit it. So I assume that they should fill out the form and submit it.
And then along with that, we have the statute says that notice of intent doesn't, it stays in effect until the special election. There's no, to call for a special election, there's no statute that says that you can withdraw the signature anywhere along the way. But it does specifically state that notice of intent is valid until, I think that was 306-015 2C.
Give me what statute are you talking about now?
306, NRS 306
01.
015 2C.
Anything more than
Pardon?
other issues that you wanted to raise? I'm not, I'm not buying the constitutional issues, and I'm not going to go into, I would imagine in terms of the argument that they're making about the petition being inaccurate. I don't know if there's a procedure well, there is a procedure for people to have their names taken off the list. And if they were inaccurate, you could have, I guess, talked to the people that signed it and got them to take their name off. I suppose you might be able to contest some signatures because they were misinformed. I'm trying to remember. It seems like I've had cases where in these initiative referendums and other things like this, these sort of people's laws where they can propose laws by initiative and referendum, and here they can recall public officers and whatever. I can faintly recall there was one where there was an issue where the people had been misinformed when they signed the petition, and they went through and showed that, and it was enough to get the signatures below. I don't see anything like that now. The constitutionality, I think the validity of the recall statute, I don't think has been questioned. And sometimes you might not like something and it might seem like it's not fair, but that doesn't make it unconstitutional. So the main issue I'm looking at is this issue of the gentleman withdrawing from this enterprise and not participating in the submission of the last couple of packets. Another issue that got raised that when I first saw it, I thought, they're right. This should have been filed in the first Judicial District Court, but this isn't. I am not reviewing the decision made by the Secretary of State. I am independently, and why the legislature would have that procedure set up in this case may be a case that I hate to even begin to recommend the legislature do anything, because every time they do it just complicates my life quantumly. But there are two separate provisions on where a case should be heard. And if it's an appeal from the decision of the Secretary of State, then like most other things, it's heard in the first Judicial District Court. I've heard tons of cases involving the Secretary of State, but this isn't that. They're contesting the legal sufficiency. I'm reading NRS 306.040 subsection 6. They're contesting the legal sufficiency of the petition, including without limitation the validity of signatures on the petition, may be challenged by filing a complaint in district court. And so, because they're not appealing the decision made by the Secretary of State, then and it's talk about form over substance kind of thing, because I spent my whole time on the bench in the 1st Judicial District Court, but here I am up in the 6th Judicial District Court hearing a case. But I think I have jurisdiction as a 6th Judicial District Court judge to hear this matter. Did anybody want to argue that any further?
Your Honor, I would argue that in Citizens v. Heller, it does specifically state that because we had an appeal under NRS 293.12793 where it went to the Secretary of State, and then 293.12795 goes hand in hand with that and provides for the appeal process for these decisions, and the sufficiency of the signatures really does that is part of that process that the Secretary of State looked at, and it says specifically that their decision is final, and then it may only be appealed in the 1st Judicial District. But it's not. It's statutes controlling the Secretary's review of the recall petition do not require a hearing. So it's not just about signatures there. It's about it states in the case that review of the recall petition. And so that's what we're looking at is a recall petition and the sufficiency of it. And these statutes in 293 interplay with 306 in many different levels, but it is clear in this part that to me, like, that an appeal would be in the 1st and would be
an appeal from her decision, which if I were to, first of all, I have no idea what the basis of her decision was, because she didn't bother to educate anybody on that. I mean, she started out, she said it was insufficient, and then changed and said it was sufficient, and didn't give a reason for either one of them as far as I can tell. But I agree with you. If this was an appeal from her decision, it has to be filed in the 1st Judicial District Court. She's not even a participant in these proceedings, hasn't been named as such. So if they were appealing her decision, I'd say, yeah, we have to go back to the 1st Judicial. I don't think it's subject matter jurisdiction. I think it's venue. And I would have to change venue down to Carson City and consider it there. But in this case, she's not even part of this proceeding. This whole, and I can certainly see where you're coming from when it says that an appeal, the decision of the Secretary of State is a final decision for the purposes of judicial review. The decision of the Secretary of State may only be appealed in the 1st Judicial District Court. And why they have 2 sections like this intrigues me. I was thinking that maybe because the sheriff wasn't part of any of that proceeding at all. He was, he wasn't part of that proceeding where she first began by saying the signatures were insufficient. And then later, I guess after the Bentos appealed, switched her position and said that there was a sufficient number. It would have been nice if she'd mentioned. I can tell you, if I were doing an appeal, if I were treating this as an appeal from her decision, I would remand it back to her and require her to tell me why she came to that conclusion. But I'm not reviewing her decision. I'm here, we've got a complaint that contests the legal sufficiency of the petition. And it says you can file it in the district court. So the only way I can make those two separate statutes, NRS 293.12795 and NRS 306.040 subsection 6 make any sense taken together is that she's not part of this proceeding. They're not appealing her decision. They're appealing the sufficiency. So there again, I think I have jurisdiction as judge, Mr. Miller. Make your right.
The first thing they stated was they're contesting sufficiency of signatures, which would be directly in contrast with the Secretary of State's decision. So at least in part, they would be.
Well, last time I checked, I can disagree with the Secretary of State. So in any event, so I find that NRS 306.040 subsection 6 applies. It says it can be filed in a district court. This is a district court, so I have subject matter and venue jurisdiction. Any other, you moved to strike a bunch of things, but I think they were filed in regards to some of these arguments about constitutional stuff, and I'm not, like I said, I'm denying that, plus the argument that the petition is inaccurate. I think that there's ways you could have gone about raising that probably, first of all, go out and get people to take their signature off the petition and or get enough people in here to show that they were misinformed about their basis for signing it. And because that hasn't happened, I'm going to deny that. I'm going to deny the constitutionality. I'm going to find that I do have jurisdiction. What I am concerned about, and if I understand correctly, everybody has agreed that there were insufficient signatures before Mr. Butterfield withdrew, and that the only way you can get to a sufficient number of signatures is to add the signatures that were submitted after he withdrew from this endeavor. And that, the statute, and I'm looking at it here, NRS 306.040 subsection 6, subsection 3 says, the petition may consist of more than one document and must be circulated for signatures, and submitting to the filing officer in accordance with this subsection. The persons filing a notice of intent shall submit to the filing officer. In this case, the first batch, the persons did that, but all of the subsequent submissions were only done by 2 of the 3. And I find that's fatal to this petition for recall. And I understand when I understand the concept of substantial compliance, because most of these cases you've cited, if you look to see who the judge was on them, it was me. And I remember the case involving the Board of County Commissioners versus Del Papa. Substantial compliance. It's not insubstantial that one of the 3 people that circulated this withdrew and then failed to submit subsequent batches of signatures. And so I'm going to, I don't know how I would word it. I'm going to grant the complaint, and I'm going to find that there were an insufficient number of appropriately submitted signatures, and therefore I'm going to order that the recall petition not go forward. Is there anything more that anybody wants to add? Mr. Balkenbush, I want an order from you. You understand what I just said?
Yes, sir.
I want you to prepare me an order.
Do that.
submitted, what?
We did have a signature from Butterfield after he signed this. He did sign the last portion. This number 53 that was in question was his signature that was notarized, and that's where the notary issue came up. And that was after, that was in January, that signature was January 7th.
He'd already withdrawn by December though, hadn't he?
But then he was signing the portion of the petition that he was gathering signatures on. So he was still complying, and he caused us to be, he did execute them, and they were then submitted. So he was a party to this all the way through. He didn't, even though he wrote that, he didn't participate with Ventos anymore.
Where do I see that in all these exhibits and stuff? Where is it? That's why I asked at the beginning, is if there were enough signatures after he quit being a member of this group. Does anybody know if that's Mr. Balkenbush? What's your response?
Your Honor, it is, what is clear in this case is that the first submission was signed by the 3 individuals who were a part of the notice of intent committee.
Okay.
It's equally clear that he resigned in December, both from the petition and also resigned his position as a member of the notice of intent committee. And what happened, Your Honor, is he signed, he did sign not as a member of the notice of intent committee, but as a circulator. He circulated a petition at one time, and he signed that to say that these people had that he walked it around and signed it, but he did not do anything with respect to his position as of the notice of intent committee. And exhibits 4 and 5 they're attached to our points and authorities are shown because he's on the first one, and exhibit 6 or exhibit number 5, he's not on it. And those are the 2 receipts for the petitions that were submitted. The first batch and the second batch is not on the second batch. And what they're talking about is him signing as a circulator of one specific petition, not as a notice of intent committee member, just as a circulator. Anybody can be a circulator for circulated petition, but what he had resigned, was not part of the notice of intent committee, did not sign the second submission as required by the statute, as the court has recognized, NRS 306.0153. And so that's what happened. He never, ever, and counsel can't point to any receipts that he made to the county clerk concerning his position as a member of the notice of intent committee after the first one. He never did. There's no evidence.
Like, does the clerk know? Do you, Ms. Spero, do you know the answer to this question?
I'm not. I mean, there was packet 53, which was submitted with the second section of petitions that I believe Mr. Butterfield was the circulator of, and he did sign the necessary document to verify that he had witnessed the people sign that petition packet. But he did not appear. I was not the accepting clerk at the time that the second portion of the petitions was turned in. It was one of my deputies, but the signatures on there indicate that Mr. Butterfield was not present at the time the petition itself was turned in. Those however many number of packets were turned in that second turn.
Well,
46 through 58.
Mr. Miller, do you want to respond to any of that?
Yes, he was a circulator at that point, but that shows that he was still active in this. They still have to go back to it. There's no remedy or no statute to provide for him to be able to withdraw from that notice of intent committee.
What it says, the statute says the persons filing the notice of intent shall submit to the filing officer And if he withdrew in December, and at that point in time, and didn't join in the submission, then I'm not going to consider any of those signatures. So anyway, that's my rule.